Eric David, and I'm a partner with the Brooks Pierce Law Firm in North Carolina. In today's COVID-19 connection video, I'm going to discuss reviewing business contracts in light of COVID-19. Now, before I start, just a couple disclaimers. I want to remind you that the content of this video is for educational purposes only. Viewing the video does not create an attorney-client relationship between you and Brooks Pierce. This video should not be considered legal advice or used as a substitute for consulting an attorney for legal advice regarding your individual situation. So with that in mind, let me talk briefly about three key principles as businesses look at their contracts in light of the business disruption and the financial stress caused by the pandemic and the government closure orders and shelter-at-home orders. The first principle is what's called a force majeure clause. Many contracts have a provision in the contract called a force majeure, which allows one party or the other to delay their performance of the obligations under the contract while certain circumstances are in place. It may be an act of God, it might say natural disaster, it might say war. Sometimes they say pandemic or disease, and sometimes they say government regulation or government order. But you want to look at the contract to see if it has a force majeure clause and if one of the provisions is applicable today with the pandemic and the shelter-at-home orders. If it is, you might be allowed or might have the opportunity to delay performance of the contract. For instance, you might have the opportunity to not pay rent during the period of the force majeure. But of course, you'd still owe that rent in most contracts at the end of the force majeure period. The second principle, in the absence of a force majeure, is what's called impossibility, or in some cases, impracticability, depending on the court. And basically, impossibility means that some circumstance has made it impossible for the parties to perform their obligations under the contract. So, an example of this would be a wedding event hall that has a contract to host a wedding, but of course the government orders make that hosting impossible because you can't have more than 10 people, in one place. And so in that circumstance, the contract is literally impossible to perform. And often North Carolina courts will require you to show that you've tried other alternatives or considered other alternatives. The third principle is called frustration of purpose. And this is where, because of the circumstances, basically the value of the contract has been destroyed. You could perform it, but the value of the contract, the purpose of the contract for one party or the other has been destroyed by the underlying circumstances and unforeseeable circumstances. So an example would be if you had an apparel company and you had ads had a contract for ads for apparel relating to the 2020 Olympics that were going to run in July of 2020. And then all of a sudden the Olympics are now moved ahead to 2021. Well, it wouldn't make any sense for you to run ads in 2020 for the Olympics a year later. And so in that circumstance, the purpose of the contract has been destroyed, and you would have the opportunity to claim frustration of purpose to be relieved from your obligations under the contract. So those are three principles that you want to look at as you're thinking about what your relief might be with a business contract. I hope today's video has been helpful to you. If you have questions, please feel free to reach out to me. Again, it's Eric David. I'm at edavid@brookspierce.com. You can also, of course, visit Brooks Pierce's COVID-19 response resources page, which is at brookspierce.com/COVID-19. Thanks for watching this edition of the Brooks Pierce COVID-19 Connection. Please take care and stay well.